Hello and welcome to today's Cordium AIFMD Surgery Webinar. It's focusing on the FCA variation of permission and business plan. My name is John Wilson. I'm Project Director at Cordium. With me in our offices are a panel of including Derek McGivney, who's Managing Consultant and Cordium has worked extensively on the RTT application process here. Bobby Jahal, a Managing Consultant and Technical Lead on AIFMD, and who's been lead developer of all of our AIFMD compliance documentation infrastructure. And from the Regulatory Transactions team, who are currently dealing with numerous AIFMD variation permissions and applications, James Lawson, RTT Team Leader, and Hector Thompson, Consultant from the RTT team. Now the format for today will be we'll kick off in a moment with Derek, who will run through some slides which are covering the variation of permission process and the requirements, some comments on implementation planning, and thoughts of firms even at this relatively late stage in the process. Through Derek's talk, there'll be some polling questions, and we'd like you to feedback your responses to those questions, and they're quite simple questions relating to the variation of permission process. And if those questions are relevant to you, then please respond, and we'll discuss those polling questions later. All the feedback that you'll be given today is provided confidentiality. Now, importantly, if this is a surgery, what we want to receive is your questions and areas of concerns with the AIFMD process and the related business plan. So at any time, please feel free to submit questions through the question panel in the GoToWebinar application. We'll receive them essentially here, and we'll seek to address those matters in the second half of the webinar. So please respond to polling questions when they arise, and also ask your questions so you get maximum value from today's surgery. Now the FCA has stated it wants to receive AIFMD applications for variations of permission within the next 48 normal working days. That's less than 10 weeks away. So Derek, can I pass over to you to expand on the variation of permission process, some of the issues that firms are facing, and what firms need to be working on in those 48 days to file a credible application to the FCA.
Thanks, John. Yes, indeed. We're going to cover the various items on this slide here today. We're going to talk about applications, some of the basics, quickly go through the timing of applications, permission requirements, objectives of the VOP, talking about your project delivery, being prepared for the submission, being prepared for after the submission because there is still work to be done, the content of the VOP, and then we're talking about business plans, content, practical issues, and demonstrating compliance with AIFMD, specifically covering organizational structure, governance and culture, systems and control sections of the business plan, which back up the questions in the variation. And then we'll come back to a couple of follow-up webinars that we are going to be doing later on this winter, and hopefully if we can't get to some of your questions that you're talking about today, we'll be able to pick them up on those follow-up webinars. In particular, picking up on things like depositories and risk management, Annex 4 reporting. So the first thing that's in people's minds at the moment is time frame. The FCA came out with original discussions about 3 months for complete applications, and then in exceptional circumstances 6 months for incomplete applications. I think for a lot of firms the exceptional has become the norm, and having gone through some of the things that you have to submit for the application and the preparations, it's been identified there are certain things that are impossible to provide to the FCA at the first date due to market circumstances. So in order to get the application through and fill out the application, you're going to need to identify your preferred authorization date. Now, there are some firms who can get in within 3 months and have the completion done based on having their arrangements in place, but for a large majority of the firms, there's still a lot of work to be done. So you are allowed to request the deferral of the determination, and you are allowed to request up until the 21st of July 2014 at the latest. And we are highlighting this because there was a worry that you would only be able to defer it for 6 months. But I think recently the FCA has confirmed that you can defer longer than 6 months and therefore submit earlier than the 21st of January deadline that we talked about, which obviously is useful for all service providers who will be dealing with having to submit a number of applications at the same time. It's also going to be very helpful for the FCA for you to identify which documents will not be available for the submission and when they will be likely to be available. Again, I think they discussed this being 1 month prior to the determination. Again, we're trying to avoid having an avalanche or a bottleneck on any particular day, if possible. And then, obviously, there's a challenge for the firm to ensure that they have all the arrangements in place by that date. So, part of the main challenges and things that people have to think about is the provision of the following documents, which is required a copy of the instrument of incorporation. That should be fairly straightforward for people. A confirmation that depository contractual arrangements are in place for each AIF listed. Again, this is probably an area of challenge for a lot of people, and it's an ongoing issue which has been dealt with by the market. And all information which will be made to investors under Fund 3.2, it's important to point out whether you're marketing or not. In order to have an AIFM license, you need to have the systems and controls in place in order to be able to provide information to investors in relation to those disclosure requirements. Even though, it should be said, some of the disclosure requirements will not be relevant. There's also some other issues in relation to the determination date for example, EU AIFs. We had one example where in Ireland, the Irish QAIF requires the AIFM to be authorised in order for the fund to be authorised. So there's a little bit of a difficulty there. But the regulators have determined to talk to each other around that time to ensure that the FCA can notify the Irish regulator that the AIFM is authorised, so that the Irish regulator can authorise the AIF, and in turn the FCA can therefore authorise the AIFM. So a little bit of playing around there, but it's something that will be worked out in the fullness of time. So in order to start off with our first polling questions, we're going to pop up a few here to get some kind of idea of when people intend to submit their application. So that's the first polling question that should be coming up on your screen now, and you'll have 3 options to pick from whether it's soon, on the particular date, or before the particular date. This will be quite useful for us for planning, and we'd ask that people answer this question if they have an application in process. And yeah, okay. So thanks for any questions that have come or answers that come through on that. The second polling question is, what date do you wish to defer your authorization until? Remembering that it doesn't have to be the 21st of July 2014. And again, we'll leave some time for people to answer those questions. All of these polling question submissions will be reviewed at the end of the webinar. And okay, moving on now to the permission profile, just some of the basics to remind people the different types of permissions that people are requesting. If you're undertaking only collective portfolio management, which will include managing an authorized AIF or an unauthorized AIF, just for a reminder to everyone, an authorized AIF is authorized from the point of view of the FCA. It may be authorized in a different European jurisdiction, but you would only be required to have authorized for UK authorized funds. So a CPM or collective portfolio management firm will be managing an AIF or managing a UCITS. In both cases, we believe it's clear that if you're undertaking those permission profiles, you don't need the other permissions, in particular advising, dealing, arranging, receipt and transmission, etc. However, if you are looking to provide portfolio services to other types of entities, such as you're delegated to another AIFM, you're providing services to individuals, or you're providing services to pension portfolios, you'd be expected to have a managing investments permission. There's also some question about residual collective investment schemes. If a scheme doesn't satisfy an alternative investment fund or a UCITS fund definition, and you wish to provide services to them even though they're a collective investment undertaking, I would suggest in those circumstances you speak to your consultants or your lawyers about whether you specifically need those permissions. Okay, so the contents of an application. We believe and we recommend that you provide a cover letter explaining the main timing issues, what you expect to provide at a later date, and when you expect to provide it, and potentially why. I think this will be useful for the case officers at the FCA to quickly determine which process pile they'll put your application in, and more clarity there will help you get through the process a lot quicker, I think. Obviously, you're submitting the variation of permission application form, which contains 11 sections with all the detailed questions that you need to complete, and the regulatory business plan, which harks back to section 4 of the variation of permission document. And hopefully that will cross-reference all the questions that are coming up and makes it clear to the FCA what you're doing. The financial projections section, section 5, will contain, the financial projections specifically will need to be a 12-month projections, and we believe that's from the point of authorization for 12 months. And from our experience working with applications, normally the best thing to do is put month 1, month 2, month 3, month 4, because just in case that has some flexibility, it makes sense to put it in that way. And then the main documents that they expect to see is fund instruments of incorporation. Fund documents, if you have them in draft, an advanced draft would be very useful, and we think it's important that even if it isn't in an advanced draft, it's important to have a draft document together because it helps you answer the questions in section 4 and complete your business plan. And then referring back to the investor disclosures, which is 3.22, in particular if you're not submitting an up-to-date AIFMD compliant fund document, you need to have maybe a schedule identifying all the prior disclosures are ready to be made. Then the next section that you'll be sticking in is your AIF schedules. There are different schedules for different types of funds, obviously a UK AIF, EE AIF, and a non-EE AIF, but there are a couple of interesting types ones. They refer to an Article 74 fund, which is a closed-ended fund that makes no additional investments after the 22nd of July 2013. Article 74, it really should be Regulation 74 because it relates to the UK AIFMD regulations. And then Regulation 75 relates to closed-ended funds whose subscription period is closed before 22nd of July 2011 and are constituted for a period that expires on the 22nd of July 2016. We think that this probably means it needs to be fully divested by that time. However, again, we would recommend, if you're in that circumstance, speaking with your legal advisors. And then, in addition, in that schedule, there's a Fund 3.22 checklist requesting where you have put your investor disclosures, what documents, where they can find them. So again, this cross-reference section is quite important. And then finally, the marketing applications that are required. The FCA recently highlighted that they would expect that the marketing applications to be submitted in a parallel format to the applications. So just moving on to what we think is important issues to think about as objectives of your VOP, and what you're trying to do is demonstrate that the applicant can satisfy the directive requirements, demonstrate that the applicant would be ready, willing, and able to undertake the regulated activities being applied for, demonstrate that the applicant continues to satisfy the threshold condition, including the new threshold condition, requiring you to ensure that your business plan is suitable for your operations. And then also demonstrate that the organizational structure, both internally and externally, will satisfy AIFMD at authorization, and that the business plan is suitable for an AIF. What are we trying to do here? We're trying to make it easy to conclude these points by keeping responses succinct, cross-referencing to specific questions, and supporting documentation, so the recipient of the file has an easy job in terms of confirming that you're appropriate to be an AIFM. Now, moving on to project delivery, some of our clients will recognize this slide from something we did at the early end of the summer, talking about what firms need to be thinking about in terms of being prepared for making a submission. We're now in early mid-November. There are still things to be done. There's still some issues being worked out in relation to depositories. There's some questions surrounding delegation. There's questions around client disclosures. People are still potentially working on the implications of these questions and how they affect their operational procedures. And obviously certain firms who have disclosable requirements under the private equity disclosures are looking at what they need to do. For the most part, the majority of our clients have received the compliance infrastructure that we have been working on for the last year, and that documentation is either in place already or is ready to be implemented once you're authorized as an AIFMD. And then obviously we'll be able to provide training, assist clients with training on these issues once they get implemented. But now the job isn't, even when you submit, the job isn't necessarily over. So the project assessment is over, but the variation of permission process still continues. Once submitted, whether it's before Christmas or in January, there will be still a period of time in which you will need to work on some of these issues in order to ensure that you can get to the position of an authorization. In particular, we understand there is some concern over trying to achieve a situation where you come to an agreement with a depository, and whether that's depository full or depository light. Firms will need to pick a date in which they're going to submit or confirm that they can submit completed documentation. And you don't necessarily, and I don't see that you have to submit a depository agreement, but it's so important that you've agreed with your depository the relationships in order to determine the implications for all the other service providers that you're providing, that you're doing work with. In particular, we're thinking, once you've determined who your depositories are, you can talk to your administrators and prime brokers in relation to the delegation activities. In fact, we believe the depository will help you with that. All this information and all these ideas will have an effect on your client disclosures, will have an effect on your operational procedures, and will have an effect on your day-to-day activities. But you've got to remember that once you've agreed a final contract with the depository, you may have made some statements in your business plan at an earlier stage when you haven't finalized these details, in which you need to potentially go back and reappraise the FCA of what you have done. Hopefully, we will see the FCA and depositories and the industry coming together to resolve these issues at an early stage, and that authorizations can occur, in fact, before this time. But we're just highlighting essentially there is still work to do in the new year. So, moving on to the general content of the VOP and the regulatory business plan part of it. We just thought we'd highlight some of the areas that we're going to go through here. But in particular, we're going to be talking, the content needs to contain a background to the business, which is a clear summary of the issues covered in the whole of the business plan. The general purpose is to demonstrate that the permissions sought are appropriate for the business, and the firm is prepared on a quick view to satisfy the regulations. Talks about your current status, your activities, and a brief history to the business. Your proposed business model and operating model should talk about your current customers, your regulated activities, fund structure, capital model, locations of funds, master feeder, LP structures, AIF types, whether you're NERS, quiz, whether you're in the unauthorized AIF types such as the charity AIFs or UCITS, an Irish quaif, for example, closed-ended bodies, don't forget the CCAVs, or other types of non-collective investment schemes. It would be ideal also to highlight, the types and structures. If you look at the Annex 4 submission information in terms of categories, it will help you define the type of firm that you're going to be. Okay, so in particular, we're going to focus a little bit more on these areas. The organizational structure of the AIFM, its governance and culture sections, and which refer to questions in section 4 on general compliance, conflict of interest. Then we'll move on to the systems and control sections, which refer to disclosure to investors and competent authorities, risk management, prime brokerage, depository arrangements, and finally come on to marketing arrangements. So we just thought we'd bring this slide up. But first of all, before we get on to the infrastructure or the organization, before you get onto this, you should talk about details relating to individuals and their control functions, location of personnel and mind and management, include, who's doing portfolio management, who's doing trading, what the headcount is there someone responsible for risk, who's responsible for compliance, reference your current staff chart and provide, reference the individual forms you've prepared. You don't necessarily have to go into detail about their appropriateness unless you're adding new people to the business in the interim. Then we'd expect you to discuss in detail the ownership structure, use your latest change of control chart, organizational structure chart, or controller forms. It is highlighted if you do intend to make some changes to let the FCA know that those changes will be coming soon. And then we thought we'd highlight this in relation to highlighting the discussion on the appointment of service providers. Point being is the AIFM is either doing portfolio management and risk management, or it's going to delegate one of those functions, and it will need to talk about the appropriateness of delegation of those functions and justify that delegation. But we'd also highlight on the left-hand bottom side of the left-hand section is the administration activities that an AIFM can undertake. However, it can also delegate those activities to other firms as long as they're undertaking those activities in a jurisdiction which allows them to undertake those activities without a license, or if those activities require a license themselves, in the jurisdiction that is providing the service, that those services are provided under a local license. We'll come back to the point that the AIF can still appoint the various entities and is also has responsibilities, whether it's depot full or depot light, and the AIFM has oversight duties at a later stage. So moving on to governance and culture, this is the first. Oh, sorry, I've been asked to go back to a polling question which we should have asked, which is just to confirm, have you discussed any amendments to arrangements with your service providers? And we'll give you some time to think that out and for me to take a breath. Okay, thank you very much. So moving on to this section on governance and culture. So in general, there's a section on the business plan which refers to governance structure, so this should be built on. Section C, you've got appropriate oversight in place, management information, some general information about how you're doing things and how you satisfy the governance requirements. You might also refer to your risk management policies. There's a second question, question 4.2, which talks about honesty, fairness, professional independence, acting in the client and investor interest. Can you demonstrate these within the business plan? Well, you should be able to demonstrate this because currently you're operating under those status. So you refer to your status of registered individuals, the policies and procedures that you have in place, and the current practices that are all working very well to ensure that the individuals working at your firm all satisfy those high-level standards. On the conflict of interest section relating to question 4.3, just to confirm that the policy is in place and operational. Again, you should have a conflict of interest policy already. It should already be operating, so you don't need to go into much detail here, and just provide a limited description of the operation of that policy. Okay. So moving on to systems and controls. I mean, this is one of the interesting parts in, can you rely on just having a fund document that contains all the information? Well, as long as all that information has considered all the issues that need to be considered, the point being that whatever disclosures you make has an implication on whether you can satisfy the requirements of that you have systems and controls in order to make those disclosures. So therefore, if you haven't completed the document, you need to ensure that you've considered all the points so that you can confirm that you have adequate policies and procedures and systems and controls in order to satisfy the requirements. And just briefly running through some of the ones, the highlighted ones is, the identity of the AIF depository is quite important. That might have to wait till a later time. How you comply with professional negligence requirements if you're a CPM, or with professional liability risk if you're under Gen through a CPMI. Description of all fees, charges, and expenses. Well, again, you may not know that information until you've sorted all that out over the coming months. It also highlights 3.26, which talks about the leverage disclosures, which would be required to be made where you're making changes to leverage or changes to the right of reuse of collateral, obviously you need to have policies and procedures to ensure that that takes place, but you may not have an idea of what your leverage is, or what you need to make in order for it to be a prior disclosure or periodic disclosure. And we'd also highlight the annual report obviously is not applicable for funds that are not marketed in the UK. And finally, on the reporting obligations, we highlight some additional reporting requirements to the regulator for firms that leverage 3 times and over. Moving on to risk management. So the big question out there, and I don't know if anyone noticed, the last 2 days, the FCA has come up with some interesting updates in relation to the use of proportionality in applying Article 15.1. Essentially, the question in the form says, can you demonstrate that the risk management functionally and hierarchically separate from the operating units, including the portfolio management function? It's an interesting question in relation to proportionality. When following our inquiries and submission of applications, it's been made clear that proportionality will apply, and we believe this is on the same lines as how it applies to remuneration. However, in order to answer the other question, firms still need to ensure that they can satisfy the other provisions of 3.7 to ensure that they have appropriate processes to deal with the conflict of interest that potentially exists. We would hope that all of our firms would obviously have the policies and procedures that we provided them, as they would clearly satisfy the requirements of risk management, but there might be some work to do to assist firms in ensuring that they operate at a proportionate level for the type of activities they're doing. And we'd also just highlight within this section, it might be worth thinking about, there is questions about asking you to document your due diligence process for investment activities, and we're trying to say, or you should try in there to keep it as simple as possible. So next question on the polling side is, have you documented your risk management arrangements to AIFMD standards? We expect all of our clients to say yes, but we'll give you some time. Okay, so next is some of the prime brokerage questions. I think I'm going to highlight some of those questions for the purpose of just saying that we have spoken to a number of prime brokers, and they're more than willing to come in and assist you with answering these questions. You're likely to already have systems or have arrangements in place and contracts in place. Specifically, you should focus on the issue around transfer and reuse of AIF assets. Compliance with the fund document, that's probably something of relevant interest, and you still need to have demonstrated that you've done some form of due diligence, check their background. Even though they're probably well-known names, there still needs to be things done in that regard. And also, there might be some changes to the interactions they may have with their administrators and custody providers, in particular if there's any issues with some difficult assets out there. They might be interested in if there's any changes to your investment activities. Sorry, just pulling up the next polling question. Oh, simpler one. Have you discussed any amendments to services with your prime brokerage? And we're all obviously interested. We'll be happily discuss with any prime broker out there the efficiencies we can gather from ensuring we're answering the questions appropriately. So the next section, I think, is of interest. I'm just conscious of time there, so I'll try and get through this fairly quickly. But essentially, as you know, a full scope UK AIFM of a UK and EEA AIF must ensure that a single depository is appointed for each AIF, and a full scope UK firm of a non-EE AIF being marketed in the UK must ensure that one or more entities are appointed to carry out the functions of oversight, custody, and cash management. One or more, so it can come together. And I'll just quickly move on to that question on the next slide. So, I mean, I think the point we're trying to make, obviously, if you're full scope with a AIF in a jurisdiction in Europe, you have to ensure that the depository appointed in the same jurisdiction as the fund, and it has to provide the appropriate services. If you are a non-EE AIF, you have the option of going through the depository light, which essentially suggests that the depository provides the oversight of the cash management and custody activities on behalf of the AIF, with oversight of the AIFM. It has been suggested, and it's reasonable to conclude, that in a lot of cases it may not have a significant effect on the day-to-day operation of your business, as your administrator might assist you with cash management, your prime broker may be custodying the assets, and it just requires the additional insert of an oversight function in there with a regulated firm that can provide depository services. This is we are starting to see a lot more depository service providers in different jurisdictions out there come to us with their service, identify that they can do it, identify that they actually have documentation to engage with you, to discuss with you your needs. They will be happy to speak with your administrator and prime broker in relation to the interactions that will happen, and obviously they want to get your business. Obviously there's a conversation that needs to happen in relation to fees. We believe that there are solutions coming out, and we have heard that there are firms out there willing to submit documentation. However, or have documentation ready to sign, and lawyers have seen them. So we can't get involved in the negotiation side of it, but we're happy to assist our clients with discussions in that regard. So what does the FCA expect on depository arrangements? Confirm that the AIFM has performed some due diligence. That due diligence would include contact meetings with the depository, information on the service provided, starting contract negotiation, assessment of reputation, copy of report and accounts being obtained, etc. We want to see people pushing into that situation. The FCA, I think, wants to be assured that the firm has tried its best to deal with all the issues that are potentially coming up, and that they need to address. And and we'd be happy to speak to any clients who's still having difficulties in this area, because we'd be interested if there isn't solutions out there, and that we'd be interested in taking that point to the FCA, because they're interested in actually seeing the solution come out as soon as possible and allowing you guys to be in a position to comply with the directive as soon as possible. So we're moving on to this, our polling question 6. Have you seen a draft of the depository agreement? And just while you're answering that question, just to highlight, I think we were discussing today, you don't actually have to submit the depository agreement. The point being, once you have that agreement in place, you then can agree all the relations with all the other service providers within the structure, and you're in a position to be able to complete your disclosure document, which then puts you in a situation in which you're able to supply it to the FCA. So I'd like to hand over to my colleague Bobby Johal to talk about marketing, just to give my voice a break.
Yeah, thanks, Derek. So there's a couple of different permutations depending upon the facts of your business and your structure, and how one notifies the FCA of your marketing intentions. So first up, if you're a full scope UK AIFM that's marketing a UK or an EEA AIF within Europe, there are two different forms that you need to consider. The first is the notification of intention to market within the UK. Now this form is a part of the VOP pack. The notification of intention to market in the UK for either professional or indeed retail investors, that's a possibility too. Also further, if you intend to market EEA-wide, you of course do have the possibility of obtaining an AIFM passport for marketing purposes, and you can do that within the scope of the VOP. Needless to say, the requirements in terms of notifying the FCA of your intentions are set out in Annexes 3 and 4 of the Directive. And the detail that will be submitted within the forms that are listed there. So some information about the facts of the AIF, its instruments of incorporation, depository, etc. So there's some information required there. It's noteworthy that if you do, if you're not intending to promote to retail investors or market to retail investors, you'll have to disclose some information about the controls you have in place vis-a-vis limiting your marketing scope just to eligible professional investors. And also noteworthy there is, of course, the SDA's recent changes in respect of NMPI. This is non-mainstream pooled instruments and the investments, I should say, and the SDA have tightened up their rules around for the possibility of marketing to retail investors. So please to be cognizant of those changes that are upcoming also. So secondly, the second sort of scenario is a full scope UK AIFM wishing to market any AIF. That's a slight typo there. Wishing to market a non-EEA AIF need not complete the marketing, or actually cannot complete the marketing intention notifications in the VOP form itself, but will have to separately file under the MPPR regime, the National Private Placement regime. That notification in respect to, there's a few different scenarios one needs to consider here, but if you are a UK manager, full scope manager marketing a non-EEA fund, you shall have to make a notification under Article 36 of the private placement regime. And then there are a few different other scenarios which aren't necessarily strictly related to the actual VOP process, but are pertinent and relevant for third country managers also. So we list the scenarios there, but in short, if you're a full scope third country manager marketing an AIF, you shall need to submit an Article 42 form. And again, just to repeat, this is quite separate from the variation of permission process. If you're a sub-threshold UK AIFM, so not applying, so the full implications of the directive wouldn't really apply to you, wishing to market to the AIF in the rest, wishing to market your AIF to investors around Europe, you can't actually attain the passport, of course, unless you opt up to full scope status. So that passport isn't available. So you need to be make yourself cognizant of the local private placement regimes in the jurisdictions in which you intend to market. And just that final scenario there at the very bottom, if you're a sub-threshold non-EA AIFM, in other words, a third country AIFM marketing an AIF, you should need to complete the small third country form, again using the National Private Placement regime. Just in closing, just some very quick information, the quick summary rather than the information required as part of the MPPR notifications. So you need to submit some basic information about the funds that you intend to market, information on any delegation arrangements you have in place, information on your valuation agents or your independent transfer agents, details about prime brokers, independent auditors, and any other entities that are marketing your AIFs on your behalf in the UK. And also for the Articles 42 and small third country forms, there is information also required about custody arrangements, and rather peculiarly the small third country forms do actually require some additional information about the category of assets that are invested in the AIF and the use of leverage and or borrowing. So I think that concludes the main part of the presentation. And I think if I hand back over to John.
Okay, thanks very much, Bobby and Derek. We are getting questions through from the participants, which is excellent. If you do have more questions to ask, anything apparent in your mind from the presentation, please put the questions through, and we'll try to deal with them. One question I had come through, which I can't do straight away, is a question around the slides. We will be distributing slides as a PDF along with a recording of the event after today's webinar, so they'll be coming through to all participants after the event. If we can turn to the polling questions quickly, we'll just see what the feedback was on those. When do you intend to submit your application? Before half the community there before 22nd of January, and interestingly, quite a large amount of people holding out till 15% holding out to in the middle of April, which is 3 months of permissions. I wonder if.
Well, I'm just thinking maybe that potentially my fault there. We put I put the 22nd of January. Obviously, people aren't going to submit on the 22nd of January. They probably submit on the 21st. I hope that hasn't skewed the results.
So it might be a skewed impact there. Okay, well then we'll move on to the next slide, one question, which was regarding the authorisation date. What date do you wish to defer to? And clearly a large majority of the participants there wanting to go at the latest possible date. And Bob, would you say that sort of general feeling from clients?
Yes, absolutely. I think that's precisely what we've been hearing from our client base, and also actually from the FCA too. They sort of anticipated a deferral date in July. That's not unexpected at all.
Briefly, 1/5 there, looking at no deferral at all, which is an interesting point, which means that they're certainly confident about their preparations.
Yeah, which is excellent, which I think the FCA would be glad to hear about.
Yeah. On the next polling question, we asked in terms of have you discussed any amendments to arrangements with service providers? 62% yes, 38% no. I guess, Derek, that's probably some firms are still making their minds up about this.
Yeah, no, I'd say in terms of, the depository issue is quite an important piece, and then that sort of floats back down into potential changes to arrangements with other service providers, but it's probably worthwhile lining them all up for when you want to be able to talk to them about potential changes that might occur.
Okay. Let me ask a question around risk management arrangements, because certainly in my experience is that people are quite confident about their risk management arrangement, comment that their documentation may not be up to scratch. Yeah, it's interesting there. It's a broad split, 44% to 56%. So getting some confidence about those arrangements amongst a lot of respondents, but equally half the community there still viewing there's some work to do.
Yeah, I mean, I think definitely there's work and documentation to be done, and there's a lot of the question of have you got documented and operational policies and procedures? Yes, there will be a lot of documented and available policies and procedures. There are still a lot of questions in relation to finalising the fund documentation to ensure it's AIFMD compliant, and some questions around that, which will have to have an effect on your documented risk management policies and procedures. But in terms of having operational documents, an operational process, I think firms are getting closer to having those documents in place, and certainly we're working with a lot of clients on these things more lately than ever, and we know we will be continuing to work on those risk management policies throughout the next.
I'll probably have a question around timing of those as well in a moment. In terms of the next question we polled around services with your prime brokers, let's just see the results for that. Should be coming up in a moment. Okay. Yeah. Okay, just not refreshed on my screen. Have you discussed amendments with prime brokers? 40% yes, 60% no, which is interesting, quite high actually in terms of the persons that have not actually responded to that yet. Okay, and then the final polling question related to depository agreements. Have you seen draft depository agreements? 70% no, and I guess that again, that's quite.
Yeah, I mean, I think that's probably the biggest worry from people out there. I mean, I've heard through various discussion boards and speaking to various service providers that there are draft documents out there and that lawyers have seen them. I'm certainly going to personally pursue that a bit more, because I'd want to see that these documents are available and ready, because that the draft document is the starting point in the conversation happens from there. I know we're getting lots of contacts from service providers out there who say they're ready, but we really need to push them to get their act together so we can do it.
Yeah, and I think it's also very important that the firms themselves push their service providers too, to make sure that they're seeing that.
Okay, we're going to go to some of the questions that are coming through on the webinar. We've talked a lot about the dates: 22nd of January 21, 22nd of July. Hector, you're working on the RTT team, you're dealing with clients at the moment. What are the consequences for firms if they don't make January 21, and more importantly perhaps, what are the consequences if they don't make 22 July?
Well, if you don't get the application in by the 21st of January, then, and assuming the FCA takes 6 months to process the application, then there is a possibility that you don't get the approval of the authorization to be able to manage an AIF by the 22nd of July. If you don't get that authorization in time for the 22nd of July, then potentially you may have to cease activities. It's also very possible that the FCA will deal with applications received before and after the 21st of January in batches, insofar as applications received before the 21st of January get reviewed, and then once those have been reviewed, subsequent batch gets examined. So it may be the case that even if you do get yours beginning of into the FCA at the beginning of February, the FCA may not look at it until April, until they've dealt with the first batch. So I think important to get the applications in as soon as possible and as close to that date.
And yeah, I think if there's a lot of stress at the FCA, they'll have to take alternative measures. Considering the fact that there's a large number of applications, I think have already gone in. The last time we heard it was about 120. I think had already been submitted, and I think there was 20 had been authorised at this stage. It'll all depend on the information that the FCA receives in terms of volumes as to whether they can get the application through. But the important pieces are it's better to get it in earlier. However, having said that, there is also an argument to say that if you're getting close to having your arrangements in place and that you're close to filling a complete application, if you don't hit the 21st January deadline, that you then go for a later deadline with a 3-month window and ensure your application is complete, in which case you would have potentially the 3 months. As what the FCA will do, obviously we cannot work out what they're going to do as a result of a situation where there's a significant number of incomplete applications in at the time. But again, I think it's in everyone's interest to find some way for the FCA to allow the industry to stagger. And at the moment, it seems to be focused on these 2 points.
Eventually, though, if it's not filed by 22nd of July and firms are authorised, then there's a suspension activity issue or risk hanging over.
Yeah, and the question is whether they will actually do anything about suspension, or whether it's more of a fine or a suspension of marketing.
Okay. Also, coming out from the floor was a question around system of procedures, and this is really a question of how complete an incomplete application can be. So we talked about risk earlier and so on. I wonder, James, in terms of the system of procedures updates, how much do they have to be completed by the time the application is filed, or can work continue after that application date or before the firm is authorised?
Sure, it's much like a standard application where you can expect there to be some draft material within the application itself, but the more complete the application is, the more chance the FCA will consider it to be in what we deem to be almost a faster lane of review. If there are substantive documents missing, if there are pieces that are not in fact filled out, the FCA may deem that it's completely unreviewable because of the potential deluge of applications they're going to be seeing, and they may ask you to go away and refile with a more completed application with more information therein. This also directly reflects to, I suppose, the time taken to prepare the application. Sometimes it's good to take a little more time to prepare the application to make it a little more complete. So then you will have a better chance of being almost fast-tracked in the review process with the FCA, rather than just trying to get into the queue and then being put into a slightly slower lane box.
Mm-hmm. And I think, James, one of the key things there is identify early on what you're not going to submit, and then focus towards submitting as complete an application as possible, so that you can get it into the FCA and make it clear to them what's not complete, and don't drip feed the information through. Identify a date in which you're going to collect everything else, and make sure you can get it into the FCA at least 1 month before your date of authorization deferral, or if not more, give them more time to do that.
Is that something we'll help firms schedule to do when the application, the VOP goes in, then agree a date, timeline to actually get that second layer of information?
Yeah, no, definitely. I think we need to start early in terms of thinking about what you're not providing, documentation that's going to be out there. And just coming back on the marketing point, there's a lot of information in the marketing documents that refer to issues that are going to be outstanding at the time of submission. And I'm second guessing myself a little bit here about submitting the marketing document at the time when you've got a lot of open questions. The FCA has indicated that you should submit it at the same time. We might need to find out more information about that and whether it might be more appropriate to resolve the issues and submit it in the situation where it's 1 month prior to the deferred authorization date. That might make more sense.
So having sort of broad questions, but then sort of driving down to some specifics as questions are coming through from the webinar. In terms of financials, which I think we touched on in terms of needing to be submitted, of course, people are filing applications anytime now, and then they're looking to be authorised, say, from 22nd of July. But I understand there's questions relating to financial projections for 12 months from when the firm's authorised.
Yeah.
But they don't know when that date's going to be. So what should firms be doing? Should they be spending 12 months from the application, or 12 months from when they think it's authorised?
We have a standard process in terms of applications is usually 12 months from the date you believe you'll be authorised. For standard applications, you don't know what that date is, but what we usually suggest is you pick month 1, month 2, month 3 when you're highlighting your monthly basis, as you don't take into account year-end as much, and you just talk about your financial projections in a simple timeline basis. So that allows the FCA to have some flexibility on when that is, and it makes the information a little bit more easy to handle. And don't worry about whether your tax year-end comes in and things like that. Okay. Another question, quite specific, again coming in around depository arrangements. So you've got a situation whereby a non-EU AIF, EU AIFM is managing a non-EU AIF, but it's not marketing in the EU. And the question is asking around depositories. Do they need one in such situations? Can I ask Bob, you pick that one up?
Sure. The short answer is no, but it's very important the message should be very clear. If there is no genuine intention to market, the depository requirement is switched off. But that fact should tally in very squarely with what you've submitted in your variation application. Variation permission to the application itself should be complete with that idea. And most importantly, the business plan should really envisage and have a clear narrative that states that that's not within the foreseeable future an intention to market. So in short answer is no, but that should be, it's very important to make sure that your business plan envisages in full what your intentions are, and marketing should not be one of those intentions if indeed you elect not to market and indeed you elect not to appoint a depository.
Okay, that's great. And then perhaps I can stick with you, Bobby, actually, for another question that came in, because you touched on the marketing slides earlier. Again, sort of a non-EU AIF situation. So you've got a non-EU AIF, non-EU AIFM. Do you need to submit a notification to the FCA, presumably of your marketing, because you're not if you're managing?
That's absolutely correct. So the directive at the moment does not envisage that non-EEA AIFMs can apply to be authorised under the directive. That's a conversation to be had from 2015 onwards. That is actually suggested in the directive that conversation will be had at EU level, whether it's possible or not for third country managers to be authorised under the directive. So until that time, the variation permission application itself only pertains to UK authorised firms, or indeed EEA authorised firms. So in respect to notifications to market, absolutely. If you intend to market under the national private placement regime, which is the only way one can market, you need to check the circumstances of the implementation of the directive in each member state that you intend to market. Taking the UK, for example, you would need to submit the Article 42 notice of intention to market, and it's important to note that in the UK this is a notification rather than an approval process. So when one submits a complete Article 42 form, one should receive a response from the FCA, and that receipt and confirmation of the receipt of a complete filing should then allow you to go ahead and market. And so it's not an approval process; it's a notification process.
Okay. And one more subject, again, marketing with Article 42, which is for non-EU AIFMs,
yeah,
and Article 36, which is for EU.
That's correct.
Questions coming from the floor in terms of whether the Article 36 notification form goes in at the same time as the VOP. I think Derry, you can pick that one up. Sorry.
Yeah, I mean, this goes back to that point. Is they are generally expecting. The FCA indicates, I think, at the Asset Management Conference that they would be expecting to see marketing documentation, which was a new thing to us, and also they'd be expecting to see the documentation for marketing. But I suppose just harking back to just to highlight, a lot of the information brought in relation to marketing relates to the third parties you're going to use. So that form will have to go in a draft format. So potentially, the issue being, it's more appropriate to submit that document 1 month before your date of authorization, as opposed to potentially 5 months before authorization. And hopefully by that time you should have cleared up all the outstanding issues that are necessary to be considered within the form. So even though I think and I'll check this with the FCA, even though I think the FCA were suggesting you put it in with the application, it might actually be better to wait until closer to the point.
Okay, now another topic that's come up is delegation, and I know delegation has always caused a lot of concern, and it seems to me the issue's moved on from the whole letterbox entity issue and conceptual thing to actually now, who do we delegate tasks to? Questions coming from the audience: if delegation is performed by the AIF, the fund, are those functions outside the duties of the AIFM because they're not being delegated by the AIFM? I think in the directive there's an emphasis around risk and portfolio management. Is that right?
Yeah, I think there's two issues. There's two issues that are coming down here. One is it will be impacted by the legal arrangements in relation to the local rules on the fund structure. So the quiz rules and the NERS rules will have a discussion on who can do what. From an AIFMD perspective, the issue is everyone seems to have to be looking at everyone else in terms of what they're doing, but generally the AIFM has overall responsibility for ensuring compliance with the directive, and the depository has overall responsibility for compliance with ensuring that the assets are kept in an appropriate way and satisfying their responsibilities under custody, under safekeeping and oversight. So I suppose maybe I'm fudging the answer there. The AIF can legally appoint the entities to undertake the various activities, and there will be legal responsibilities there, but the AIFM will be responsible for ensuring that those activities are undertaken in an appropriate manner. Traditional structures, AIF structures that we've always seen is for example, the AIF appoints the administrator to undertake the activities, and as a result of that, the administrator potentially is undertaking the unit share dealing kind of act. Whether that's actual dealing or not has always been a question that's been up in the air in terms of specific resolution. But from an FCA point of view, if it's happening outside the UK, it's happening in a different jurisdiction, and potentially that jurisdiction is dealing with that issue. So this is unit share dealing. But in answer to the question in a long way around, yes, the AIFMD is responsible to ensuring compliance with the directive, or sorry, the AIFM is responsible for ensuring compliance with the directive. The AIF can legally appoint other parties, but each party, in particular the AIFM and the depository, have specific regulatory responsibilities. And essentially nobody can do anything in a jurisdiction that they wouldn't be allowed to do unless they had a permission to do so. And potentially in the offshore jurisdictions where AIF activities may be undertaken, obviously we need to see a memo of understanding between the regulated entities to allow them to do those activities.
And there is this kind of woolly language in the directive around the share registration, the share dealing process, which puts requirements on the AIFM to ensure that certain information is obtained by whoever's providing that service, or to do as much as possible to ensure that. Which is, since the relationship is often quite a close one, probably places some responsibility on the AIFM.
Yeah, I think it'll all come back to the AIFM if it goes wrong, but there would be the legal arrangements to determine the relationship of the service.
Okay, we've probably got time for just one quick question, and this is coming a couple of related questions around sub-thresholds. A firm that actually considers itself borderline sub-threshold at the moment, and has asked really two questions. What should they do if they exceed or are at risk of exceeding the threshold during the application process? So I guess that means should they be filing an application just in case? And then also, if they're sub-threshold, UK AIFM managing non-EEAs, do they need to appoint a depository? Bobby, do you want to pick that one up just as a planning point?
Yeah, absolutely. The latter question is a simple one to answer. The directive, in the UK at least, the FCA have chosen to exercise the number of derogations allowed in the directive, and chosen not to essentially impose any gold plating of the directive upon sub-threshold managers. So in other words, you do not need to appoint a depository as a sub-threshold manager. Indeed, much of the directive is applied, much if not all of it. One of the important things you will need to be cognizant of, and this probably feeds back to question one, is you would need to keep a very close eye on your assets and the management to ensure that you remain underneath the threshold, beneath the thresholds. There are specific time requirements around monitoring the AUM levels. I mean, you meet that on an annual basis, the directive stipulation, of course. Commonly speaking, people do it much more frequently than that. But if you believe that your AUM will exceed the thresholds, i.e. the 100 million or the 500 million without leverage, you would need to consider whether that situation is going to be a permanent situation, and whether that you envisage that will persist for more than 3 months, I believe the directive says.
Yeah.
And if you if you do believe it's not a permanent situation, you would need to notify the SDA of an intention to apply for full scope permission within 30 days of that breach of the threshold. So the short answer is you need to keep monitoring your AUM. If you believe that there is going to be a permanent excess of AUM over and above the de minimis threshold, then you would need to apply for full scope permission.
Thanks, Bobby. That's very helpful. I have one quick question which came in, asked a question around how many people were in those polls, the poll stats we saw. We got 70% response rate coming through from the callers, so that is excellent. It's probably around 85 people actually responded to the calls, I've estimated. So that's probably a good sample size in terms of sort of polling feedback. Slides up in terms of future dates for our future webinars. Next one's in a fortnight's time, covering risk management. I'd like to thank everybody for the questions, sending in the questions and contributing. I'd like to thank all the participants and organisers of this webinar. If you do have questions, then please contact your consultants, or also contact Sarah Donnelly, whose name was up at the end of the slides. Please feel free to ask questions or to dial in for the future webinars, surgery sessions that we'll be running. Thank you very much for listening. Thank you very much for your contributions. And look forward to the next webinar in 2 weeks' time.